Hi there. Welcome back to Maryland Divorce and Custody, Celebrity Divorce Edition. We are on part 3 of this fun little project. I am here with my very, very good friend, Melissa McDonald, and we are going to talk about maybe the biggest celebrity divorce out there. It has been raging on for 3 or 4 years now. We're going to talk about Brad Pitt and Angelina Jolie. There is plenty to talk about. We could probably do this for days, but Melissa and I have kind of whittled down some good topics to talk about. And I'm going to turn it right over to her to get a little bit of a summary, and we'll go from there. Melissa, thanks for joining.
Amos, thanks for having me. It's so much fun to be here. As we do these, you can tell the passage of sort of COVID time because my hair just gets bigger and bigger. But we'll get right into it here. Brad and Angelina is like the celebrity divorce of our generation, it seems like. This has been going on since 2016. Angelina filed for divorce in 2016. Now, we previously talked about, and you've mentioned that oftentimes when celebrities, high profile people get divorced, that there's a lot of sort of behind the scenes wrangling before people file. And that was not the case with this situation. What seems to be the situation is that something happened. The Angelina and Brad and their 6 kids, were on a flight from somewhere, I forget where, to Los Angeles, and something happened on the flight. And it's unclear exactly what, some sort of altercation, whether it was a physical fight or an argument with one of the kids and Brad, allegedly. Something that was egregious enough that Angelina got off the plane, called the FBI, filed a DCFS report and filed for divorce almost immediately after that. And this has been sort of an ongoing battle since then. They had a temporary agreement pretty quickly where Brad had visitation with the kids. He agreed to do drug and alcohol testing. His visitation was supervised. There's been a lot of back and forth about Brad wanting more time with the kids. They've bifurcated the proceeding, like they actually were granted like the divorce, like the single status in 2019, but custody is still unsettled. So it's gotten to the point where they've been trying to work this out, and they have a private judge, which sounds like arbitration. And this has been going on, and now they're coming to the point where they're actually going to trial on custody. So my first question to you is, how common is it for divorce proceedings actually to go to trial? And what does it take for it to get to that point?
Oh man, so that's a very good question. And there's no necessarily set answer, but with, Brad Pitt and Angelina Jolie have access to any family law attorney they want, probably in the country, would come and represent them very happily. Except for the ones that have no longer represent Angelina, which is a different thing to talk about.
We'll come back to that.
But when you have really good counsel, you should then understand the range of potential outcomes at trial. And that's one of our main jobs, is to explain to people, to litigants, kind of what is your kind of target landing area in a trial, and do you then want to run the risk of something outside that target area, or and pay for it? I mean, that for most people, trial really comes down to understanding what your likely outcomes are, and then doing kind of a cost benefit analysis of what's it going to take to present your case and how far outside or inside that target area you might land. Let me get that one. Unexpected interruption. So most regular people's divorces, if they have good attorneys, can understand where their expected outcome generally is going to be. And then they say, you could spend $5,000, $10,000, $15,000 to get basically in that expected range, or you could just agree to it. And there's other things in agreements that a court can't do, so that it can be more flexible and more durable. And so that's also appealing. So a lot of divorce cases, and especially custody cases, will settle for those reasons and resolve by agreement. Now, if you have a situation where one parent wants to move children out of their geographic area, and it's going to kind of lead to a kind of uncompromisable situation. Those cases routinely go to trial because there's going to be a clear winner and a clear loser, so to speak, with time with the child. If two people are living on the opposite ends of the same town, it's fair, and everything else falls into place, it's fairly easy to share custody. If we have a situation where, let's say Brad Pitt wants to live in Los Angeles, and as we've heard, Angelina Jolie might want to live abroad, then that outcome is much more likely to go to trial because only one person can really be victorious there, and a lot hangs in the balance. If Angelina gets to move with the children to Europe or Australia or X, Brad Pitt is going to have to make some significant adjustments in his life and where he lives if he wants to regularly be a part of his children's lives.
And that seems to be what the situation is, where Angelina, well, first of all, seems pretty dead set on the idea that she wants to have sole custody of the children, that she does not want Brad to have any sort of say in legal custody. And that might be because that was sort of what the situation was when she was a kid. Like, her parents got divorced, her mother had sole custody, and her father was basically out of the picture. And she basically wants Brad to be out of the picture. But, in 2020, it seems like, your courts aren't necessarily going to do that the way they maybe would have done that in the past. Just, if a parent wants to be in their kids' lives, barring some sort of pretty extreme circumstances, I would think that they're going to be permitted to be in their kids' lives in some way. And she also does want to, be able to move the kids abroad and move at like a, sort of at will or on a whim. And Brad has expressed in the media that he wants to, have the kids in Los Angeles and be in like a sort of stable situation. And Angelina, frankly, seems not interested in that.
Yeah, and for regular folks, I think Angelina would be looking kind of at a very significant uphill battle at this point. The court systems and programs in support of children of divorce do a lot of research on these topics. And what they really look at is consistency for the children. And a celebrity or otherwise nomadic lifestyle is pretty outside of the box, whereas most research indicates that children do better when they have consistent roots in their communities, consistent routines, that the parents do everything they can to kind of keep those routines going through any kind of change in access or custody. And a lot of times clients can be frustrated by this if they are unable to kind of separate the idea of being connected to their children versus being connected to their former spouse. And some clients feel very kind of like handcuffed to where their former spouse lives. But in reality, from the court's perspective, it's much more, you need to stay close enough to your, if you want to have, say, shared physical custody or a 50-50 custody situation, you have to stay close enough where logistically you can do that, where you can take your children to soccer practice or to band rehearsal or to art class. The things that your children should be able to continue to experience to do, you've got to be able to be in that community and be in that area to make it happen. And that's what all kind of the latest research says about what's best for children that are products of divorce.
That makes sense. So one of my other questions was, as part of the temporary, sort of circle back to the temporary agreement and what was going on, for a long time, Brad only had supervised visits of his children. And, that sort of jumped out at me as something that, what sort of circumstances would the court order supervised visits only, especially for someone who is, frankly, like a rich white guy who's going to get like every possible consideration, a celebrity, what sort of circumstances would lead the court to require that visits be supervised?
So that's a very good question. And there's a little bit, I think, of what you let in with. There's a little bit of where there's smoke, there's probably fire. Something happened on that plane.
Something happened. Something really egregious
reacted super strong. Filed something with like federal authorities, immediately filed for divorce. And then instead of defending his name, clearing his name, especially in the public, when you're a public figure like Brad Pitt is, he didn't do that. He entered into a temporary agreement in which he's going to have supervised access with his children. And there's really, in my estimation, no reason to agree to supervised access other than if that is what is fairly likely a court would order you to do after a hearing. So what is that? What could possibly that look like? It comes down to the safety of the children, right? So you could have a situation where there's physical abuse, some sort of physical encounter, some sort of loss of control, of anger management of a parent where they hurt or harm their child. It could be some sort of like ongoing neglect that you might, only really hear about on the news. Substance abuse while a parent is supposed to be in charge of caring for their children, and therefore they are unable to care for their children, or some form of emotional abuse where a parent can't help but say things that are truly harmful or truly damaging to a child's self-esteem. You then have a need for there to be a third party in the room that can intervene and or put a stop to or try to have a chilling effect on any of these negative behaviors. And again, for anyone to agree to that, I mean, it's unpleasant. These people get paid. They sometimes keep notes. They can record your access with your children. They can be called as the court's witnesses or even your other spouse's witness to testify about it. To put yourself in that type of position and for it to even be considered that would be a good thing for your children, take yourself out of whether as an adult you would want to agree to that, whether you should expose your children to that as an additional calculation. There's got to be something very significant. And the fact that Brad Pitt chose to kind of quietly say yes to that kind of indicates to me that something did happen, and there was a problem at some point. But those things also aren't permanent. People that have, let's say, alcohol abuse, someone with alcohol abuse, someone who's an alcoholic, can get back into the good graces of the court and get significant custody of their children if they can get their act together, if they can clean up, if they can get sober, if they can demonstrate, that the children would not be in danger in their care. You can overcome that. You can overcome, anger management problems with the right therapy, the right treatment, and the right, length of good behavior. Custody decisions are not permanent, and the parents are taken as they are, and each time they come in. So that's why we might have seen something temporary with Brad Pitt, and then a few years later, him saying the temporary thing that we did before is no longer necessary.
I mean, I think there was a combination. It seems like there's probably a combination of those things going on. And it's worth noting, we read a lot of these articles, and a lot of the news media, you have to take everything that they say sort of with a grain of salt, I think, just because of the way they report on things. Like, they don't necessarily understand legal stuff or, how things are working. Like, a lot of the articles will say, oh, well, family services cleared him of any abuse. Well, that's not what happened. They just decided they're not going to act on it. And think about what family services in Los Angeles, with their limited resources, what they're going to act on versus, what they think that people can manage on their own.
So great point. So we have Child Protective Services in the state of Maryland. And when Child Protective Services investigates an allegation of abuse of a child, they don't clear anyone. They might issue, say that that they didn't make any findings in support of the allegation. But they're not going to say that this did not happen. They'll just say that, that there's no longer going to be an investigation and there's no finding of abuse. They didn't find an affirmative act of abuse. So there's no such, at least in Maryland, there's no such thing as Child Protective Services says I didn't do it. That's not what Child Protective Services does. They don't make those types of investigations. They don't make those conclusions from that type of investigation.
Right. So sort of same on the criminal side. You're not asking a jury to conclude that you're innocent. You're asking them whether the burden of proof has been met for conviction. So, a subtle but important distinction. So the next question I have was, this is going on, and these kids aren't really kids anymore. I mean, they're still kids, but they're teenagers for the most part.
Yeah.
So, and some of them have sort of aged out of some of these considerations. At least one of them is in college. It's the oldest one's in college at this point. So I guess I have a twofold question. At what point can kids decide, I do or don't want to see parent X, and that's that. I decide, I don't want to see dad on my visitation days, or I don't want to see mom because of my strained relationship with her. At what age are kids allowed to make that determination? And, at what age, and also at what age is the court going to, because maybe if you're not at that age, at what age is the court going to consider what the kids want in making its decision about custody?
That is a great question. Both folds of that question are very good. And we get it all the time. And the answer is never quite the same. It is very much one of those classic legal answers. It all depends.
It always depends.
It always depends. So in any situation like this, one of the things I first kind of say to clients, I try to calm them down and to bring them back kind of into more of a level space, is no matter how old your children are, do they get to decide if they get to do drugs? Like, do they get to, no matter how old your under 18 children are, when do they get to decide that they get to drink in your house or that they get to be violent in your home? There are certain things that children just don't get to decide, right? Period. Your 14-year-old can't tell you they're going to drive to their friend's house and have a sleepover. They don't get to do that.
Not if they want to continue to walk this earth.
Yeah, well, so if you can kind of, so people have to have that perspective, but then it's not quite that clean because the courts look to what is the best interest of the child when they are making any type of custody determination, including schedule. And so a child's refusal to go to stay at dad's house or to stay at mom's house could be kind of a justified and rational reason. Maybe dad, like we talked about, maybe dad or mom has a drinking problem. And, oh my God, I don't want to go there. I'm so always worried of he's going to yell or she's going to yell, something like that. That's a completely legitimate reason why the child doesn't want to go to that parent's home. On the other side of the coin, and I use this when I represent children, maybe dad lets the children eat chocolate for breakfast. Okay, that probably sounds great to a 7-year-old, but no adult is going to say that's a good reason why, the child should live at dad's house versus mom's house. But maybe the 7-year-old would say, oh, I want to live at dad's house. I eat all the best things there. So there is a range of reasons why children reject or don't want to go to a parent's home or favor another parent's home. And, it can range from nefarious things like parental alienation, or it could be as simple as, one of the parents moved far away from the child's community. And the court has to do some sort of process to dig into those rationales before they just rubber stamp what's going on. And there's also, I think, a generational divide in the Maryland bench, at least. Some of the Maryland bench would just kind of say, as kids get to a certain age, 15, 16, 17, they vote with their feet. If a teenager wants to be with a certain parent, the court is not going to assign a deputy to escort them back and forth. They don't want the same case in their courtroom over and over and over again because a child is climbing out the back window, running into their bike and riding across town to the other parent's house in contrast or against the court order. And so they're saying, you know what, if the child who is 15, 16, 17 maybe isn't going to stay at mom's house, I'm not going to make the child stay at mom's house. Other judges might say, what's going on to cause this? And we need to look into it because it might not be that the unfavored parent is doing anything wrong. It could be something going on inside the favored parent's home. An example that comes to my head in that age group is like significant others, boyfriends, girlfriends, what have you, of a teenager. If one parent is allowing the boyfriend, the girlfriend, what have you, into the home unsupervised, that's all a teenager might think about. Like, oh, like, great, that's what I want. So it can be very difficult. And oftentimes, like when I represent children as a best interest attorney, the parent who's kind of favored will be like, well, why aren't you listening to my child? They want to live with me. Where the other side is saying, the only reason they're saying that is because of this reason. And you'd risk, if you're in that situation or if the court's making a determination like that, it's really important to kind of do a dive and understand why the children are kind of saying what they're saying.
Yeah, dad doesn't really properly supervise me isn't really a good reason for the court to say.
I had a notorious case where I represented a child in high school and the child went back and forth between the homes, basically because they didn't want to follow anyone's rules. And so as soon as one parent tried to enforce rules, the child went across town to the other parent. And the parents were so mad at each other from years of discord and acrimony, they never just got on the same page and enforced the same rules or enforced the other one's rules. And so they kept getting kind of screwed by the kid. And the kid is obviously going to have.
That's really unfortunate.
That's unfortunate, but it happened. I mean, it happened 6 times in the case, back and forth, back and forth. And all I could say is I can't, there's nothing I can do anymore, because the two of you have created an environment where the child kind of, rule shops.
Yeah. Future lawyer.
Yeah.
Yeah, so and I'm glad you mentioned parental alienation, because that was something that people say came up in Angelina's case. At one point, a judge told her that she needs to do what she can to try to repair the relationship between Brad and the kids. So what is parental alienation, and how do judges deal with that?
Man, parental alienation is a really hot topic. And it's one of those things that also kind of makes practitioners' lives very difficult, because it's a very Googleable thing. And so it's also, and it's something you can easily point to someone else and say it's their fault. So there's lots of claims of alienation. There's far more claims of alienation than I think actually I think occurs. And alienation is also one of those things where it's a spectrum. It's not like a full, one way or another. But the general concept is that one parent, either intentionally or unintentionally, has exerted influence over the child or children involved, so that they no longer favor, or they blame, or they don't like, or they don't love the other parent. And it's a very sad situation, because a court can't really fix it. It is a therapeutic process only that can fix it. And even then, the success rates are not particularly high. But if a child has been alienated from a parent, a sheet of paper that says order or judgment at the top, signed by a judge at the bottom, doesn't fix the problem. The most drastic tool that the court has in that situation is kind of completely flip custody and put the children in the sole custody of the parent who is not doing the alienating. But sometimes if that process, the alienation process, has gone on so long that that's not healthy. And a mental health professional with training in this might tell you, or might tell the parent that has been alienated, you have to wait it out. Maybe they go away to college, and they get away from the alienating parent, and they kind of wake up and see, that they've missed out on this relationship. I mean, it's tragic. It is really, really hard. But on the other hand, it's also brought up all the time by parents that are saying that have a problem with their relationship with their kid, and they say, instead of taking responsibility for it, they just start saying alienation, 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 and then none of the signs are there. None of the textbook things that we look for are present.
Right. Would children holding sort of accurate assessments about how their parent has behaved, or a parent reporting accurate things that the other parent has done, would that qualify as alienation?
No, I mean, kids
that's not really alienation, right?
In best case, the kids are out of this thing, but they're not. Kids, especially in this day and age, have access to, sometimes they're getting their parents' text messages, who knows? But they've got a lot of information, and they can in some cases relay that accurately. What you're looking for in parental alienation is one of the signs, but to respond to what you're saying specifically, is when a child kind of has problems with a parent that they can't really articulate. They can't drill down. They're uncomfortable. They don't feel right. There's this kind of nebulous negative feeling about the other parent that once you as an attorney, if you're representing the child, or maybe the parent or a therapist, tries to drill down on and says, well, what could so-and-so do to make you feel more comfortable? And all of a sudden they don't have an answer to the secondary follow-up question, because there's actually nothing there. They've just been trained to think that something is there. So rather than getting accurate reports, you're getting kind of vague nothingness a lot of times. And
so it wouldn't be like, I don't like how mom treats dad, and that makes me mad, or mom's, I know that dad cheated on mom and I don't like that. It wouldn't be something like that. It would be
for the allegation of cheating, that could go both ways. If mom is telling the child that dad cheated on mom to drum up sympathy for mom or anger against dad, that is a sign of an act of attempted parental alienation. If the child just knows it, it is what it is. if a child feels that one of their parents is I don't know, mean to the other one, that's not parental alienation. That's just how the child feels. Now, here's a kind of example, piggybacking off that. If the child thinks that for some reason they are unsafe around the other parent because of things that their custodial parent tells them about the other parent, but as an objective outsider of the court system, you say that person's not unsafe. That is a sign of parental alienation. But if one parent acts poorly at exchanges and makes the kid feel terrible, in a parking lot when they're getting in one car from the other, that's not parental alienation. That's just acting like a jerk.
Right, and sometimes those chickens come home to roost.
Yeah.
I don't know. I think I hit all my custody points, but I did have sort of, and you had touched on this before. Angelina has gone through quite a few attorneys, and attorneys have withdrawn, and attorneys maybe have withdrawn of their own accord. Now, certainly clients can fire their attorneys, and that's fine, and they have their reasons, and that's whatever, that's the thing that happens. I've been discharged in court. It's, always very entertaining, I'm sure, for everyone else who's in the courtroom to see it. What would it take? I'm not allowed to fire clients just because of my job. I have handed off clients at very rare occasions that I've mid-representation, handed off a client. And once it was because the guy was not incarcerated and he threatened me. So I'm like, well, I'm not going to represent you anymore because I'm afraid to meet with you. So, ta-da, I'm just going to give this to another lawyer and be on my way. And funnily enough, that other lawyer was the male lawyer that you know very well. And he told my client, the former client, the exact same thing I told him, but it was much better received from male attorney. But anyway, that's neither here nor there. What would it take for you, because you can fire clients, what would it take for you to, what would it take for you to fire a client? I mean, can you fire, I guess other than they aren't paying you anymore.
Sure. So it's a contractual relationship, right?
Mm-hmm.
When an attorney-client relationship doesn't work, it just doesn't work, right? There may be philosophical differences, and there also might be ethical differences. An ethical difference, if a client wants you to do something that you're not going to do, that's a reason to get out. If your client has misrepresented something under the penalty of perjury, whether it's through testimony or signed answers, and they won't let you rectify that error or that misrepresentation, you got to get out. So there's those two. There just could be personal discord between an attorney and a client. You might just not like each other. You might, from the client's perspective, an attorney might not be responsive enough or take their claim seriously enough or speak to them in the manner that they want, and vice versa. If you have a client that's beating down your door that wants walk-in appointments maybe, or is calling you 10 times a day at some point, or they're yelling at you. We have fired clients in our office simply because they're just heinously rude to us that are trying to help them. So you have those things. Then you also have the payment situation. If a client is not paying you in a family law case, you can get out. It is not a public defender situation. There's no right to counsel in a family law case. So if your client is not fulfilling their obligations under your retainer agreement, you have the right as the attorney to get out of the case. When it comes to Brad and Angelina, payment's not the issue, right? The issue. So the other ones that I kind of started with is kind of what might be cooking with Angelina. And the first attorney that Angelina got was Laura Wasser. Laura Wasser is like the tabloid queen divorce attorney. I think all the Kardashians have Laura Wasser on speed dial, right? She's that type of big time attorney. So she's out. And so that makes you kind of wonder why. And then only a few months ago, there were two attorneys of record representing Angelina in the public court file. And one of them, who's also kind of very highly, doesn't kind of have the tabloid following, she's now out. And so it could be that Angelina fired her, or that attorney could have decided to get out. And as is the attorney, when you're getting out of a case, you can't, or you shouldn't, I think you can't say why, because you might be prejudicing your client, or you might be violating the attorney-client privilege. So oftentimes there are these very dry kind of like, we have decided to terminate the relationship, or it's in everyone's best interest that the relationship ends, without any kind of real reason. And the court doesn't ask for a real reason, it just will let you out. But so this Angelina thing, if I had to kind of just put my finger in the air and take a guess, is I think Angelina, like I said, has an uphill climb on certain issues. And it may be that her attorneys have told her, like, this isn't going to work. You know, your expectations of the trial outcome or what you want is not likely, is not going to happen. And I'm not going to do the things that you may want me to do to try to influence anyone to get to that point. So it's very interesting when someone is kind of prestigious, because it's just being attached to Angelina Jolie's name would be a wonderful thing for a divorce attorney. But also the billable hours that come with it. I mean, that is probably a full-time, they probably each have like 5 or 6, you know, associate attorneys, staff, paralegal. They probably have like a, you know, full factory working just on Angelina's case. So to get out of that case, to me, represents something pretty significant happened. And it could be that Angelina just said, I don't like how you're talking to me. I don't like your philosophy. Some clients, if they read your emails with opposing counsel, they want you to be tougher. They want you to cuss them out. They want you to be this, that, or the other thing. So you don't quite know why a relationship would end. But that is a heck of a good question. And you know, I don't think we'll ever know the answer, but it's an interesting one.
It is an interesting question, because this plays out so differently on the criminal side, because when you have a Rule 4-215 discharge, like, that's all out there on the record. And it does always feel very ethically dicey. Like, the judge, you know, my client has to put the reasons on the record why they want to discharge me. And sometimes I'm just like, this is whatever. But, you know, the judge will turn to me and say, well, what do you have to say about it? And I always am kind of like, do I need to say anything? Like, I don't want to throw my client under the, you know, even if they're about to be my former client, I don't necessarily want to throw them under the bus, or I don't want to say like, this is what I told them, or this was my advice to them.
Yeah, and then in my line of work, you just can't do that. You can't. Right. You can't put in emotion, you know, so-and-so wants to, you know, pick the kids up in the middle of the night and drive to Texas. You know, you just can't do that. So right. Yeah, plays out differently on the criminal side, because the judges will be like, yes, I need you to respond. Tell me how you respond to these allegations. Okay. Well, Melissa, thank you. This was great. It's been a little too long since we did the last one, but I enjoyed it. The mothership of celebrity divorces, Brad and Angelina. And still going on. It's still going on. So after all these years. Because we need to talk about how they got a private judge, because that's a pretty big deal. But for the time being, I'm going to let you go. Thank you. For everybody who watched this video all the way to the end, you can contact me with any questions at Weinberg Schwartz at 410-997-0203. And if you like this video, like this video, comment on it, share it, as Rory might say, smash that like button. Smash the like button. And we'll do this again. Thanks, Melissa. Thank you so much.